Thanks so much, everyone, for attending today. We're holding this seminar to celebrate the new cost protection laws, but also to educate about the laws and the protection they offer for applicants in discrimination and sexual harassment matters that passed late last year. I'm Camilla Pandolfini. I'm the CEO of Redfern Legal Centre, and we organised this seminar because we were so excited about these laws and their possibility that they hold, and also, I guess, as community legal centres and not-for-profit organisations, our role in letting people know about these laws and the possibilities of them. I wanted to start by acknowledging that we're meeting on the land of the Gadigal people of the Eora Nation and pay my respects to Elders past and present and First Nations people here in the room today. I wanted to acknowledge that sovereignty was never ceded, and also that this week is Ochre Ribbon Week, an annual First Nations-led advocacy campaign that raises awareness about the devastating impacts of family violence on First Nations women. Before I introduce you to our panel, I thought I'd just run through some logistics. The bathrooms are there and on the left, and there's an accessible bathroom on the right down the hallway. This seminar is being recorded, so if you're speaking, you will be recorded, and then we'll package it up and send it out to everyone afterwards. We're going to hear from our speakers, and I've got a number of questions for them, and then there'll be opportunities for questions from the floor, and I'll just take questions as people raise their hands. The room has microphones, so you can assume that your voice will carry. I have a loud voice, but I'm sure we'll hear you wherever you are. We're very grateful to our hosts, Swat and Carney, for hosting us this evening, who, as well as donating the space, have also donated complimentary food and drinks, which we'll have after we speak. The speaking bit will just go for 45 minutes to an hour, but please do join us for drinks and food afterwards. We are, as I said, from two community legal centres, Redfern Legal Centre and the Justice and Equity Centre and the Grata Fund. And so if you're impressed by the work that we do and our speaking today, please do feel free to donate, and every donation amplifies our reach and impact. We're going to hear from three excellent lawyers today. Ellen Tilbury is a Principal Solicitor of the Justice and Equity Centre, formerly the Public Interest Advocacy Centre. She oversees the centre's work on disability rights, partnering with disability advocates to develop legal and advocacy strategies to address accessibility of transport, digital inclusion, and working towards a fairer NDIS. She's worked in the strategic litigation team at the Justice and Equity Centre since 2015, applying discrimination law to include on issues including voting accessibility and discrimination by insurers against people with experience of mental ill health. Ellen also helps to develop legal and policy responses to climate change and the energy transition with a social justice focus. Nawaz is General Counsel at the Grata Fund, a not-for-profit litigation incubator and funder, and she leads Grata's legal work on climate justice, human rights and democracy. She focuses on opportunities to use the law to achieve change and crafted the equal access costs model, which we're going to hear all about tonight. And Seri Feldman-Gubbay is a specialist employment and discrimination law practitioner. She's a senior solicitor at Redfern Legal Centre and assists with delivering the Employment Rights Legal Service, a statewide employment rights legal service in New South Wales that we run in partnership with our friends at Inner City Legal Centre and KLC. And that services migrant and vulnerable workers. She's very passionate about assisting vulnerable workers from culturally and linguistically diverse communities and working on broader law reform campaigns to achieve systemic change for these clients. Seri, drawing on your experience of running sexual harassment matters, why did the law need to change?
So I guess some background, as I'm sure we're all aware, is that sexual harassment is really prevalent in Australian workplaces. And a lot of the people that are being subjected to this sort of conduct come to legal centres because they're systemically disadvantaged people and from low income backgrounds. So we are seeing a lot of these clients every day. Just to give some numbers if people are interested in that, the Australian Human Rights Commission's 2018 national survey revealed that 39% of women and 26% of men have experienced workplace sexual harassment in the preceding 5 years, and then those figures are significantly higher for First Nations people with 53% of First Nations women and 32% of First Nations men having experienced workplace sexual harassment in the preceding 5 years. And then those numbers are also, you're more likely to have experienced workplace sexual harassment if you're from a culturally and linguistically diverse background, if you're younger, if you have a disability. So there's a number of reasons why someone might be more likely to, but on the whole, it's happening all the time to everyone, basically. So I provide advice and then sometimes representation to clients who have been subjected to workplace sexual harassment. And one of the most common concerns that these clients have is, what are the risks that I have if I proceed with this matter? And there's obviously the risk that they'll lose, but the most common thing prior to these changes that would dissuade them from proceeding with these claims was the cost risk. So there was a real risk that they could be ordered to pay for the other side's fees, and that's even in cases where they would end up being successful. So unless, if it wasn't daunting enough already for people to face the look down the barrel of having to be cross-examined by a possibly hostile other side, and then possibly being found on the record to have not been subjected to this conduct that you say you were subjected to, or that you were, but it wasn't unlawful, you also could be bankrupt at the end of the day by it. And that's a huge disincentive, and rightly so, for people to not proceed with these claims. Something else to point out also, as people I'm sure are aware, is that before court litigation, usually people attend some sort of settlement negotiation. So it could be conciliation, a mediation, or just like under the table or emails, that sort of thing. And despite improvements generally in cultural awareness and trauma-informed practice, conciliations and negotiations have proven a really tough environment for people who've been subjected to discrimination to navigate, and that's especially the case for people who aren't represented. So the reality for respondents, and I'm generalizing here, is that for most of them, they're commercially driven. They are driven by the threat of looming proceedings and reputational damage, not by a sense of justice or wanting to uphold the law. And we've seen that shapes approaches to settlement. So if a respondent hypothetically has a lot of money and backing, or an insurance company that will fund their litigation, and they're up against an unrepresented person who is now unemployed and with very limited resources, they could very well lowball an offer in a settlement process because they know, or not even offer anything at all, because they know that this person is not going to proceed with the matter any further. And so you have these really strong claims that aren't going through to hearing, but also these strong claims where complainants aren't getting fair outcomes financially, but also being effectively pressured into agreeing to really restrictive confidentiality or non-disparagement terms because of the fear of what could happen if they proceeded to a hearing, and how is that going to affect them.
And obviously there's a huge pressure or feeling that often people don't even take matters to court, but where matters have gone to court and costs have been ordered against applicants or complainants. Are there examples of that?
Yeah. So I'm going to quote the judge in, so I'm sure we all know Richardson and Oracle, which is a very important case, but there were a few different stages or iterations of that case. In the first instance, they weren't my client. Miss Richardson was actually successful in the sense that her claim was made out and there were damages awarded to her. But this is a quote from the judgment, which is, "The final outcome of these proceedings, in financial terms at least, will probably be devastating for Miss Richardson, both financially and personally. Although the findings made in the earlier judgment provide public vindication of her position, she will remain solely responsible for the payment of the bulk of her own legal costs and obliged to pay a high proportion of the legal costs of the respondents. That will be a very high price to pay for her victory." So effectively, because she had not accepted a Calder Bank offer early on in the proceedings, which is an offer of settlement with there's an indemnity for the side that's offering that amount if you don't accept it, and then you're ordered to pay lesser damages in the end. Sorry, I didn't explain that very well. The other side made an offer, and it was for an amount that was greater than the amount of damages that that Miss Richardson ended up being ordered in her favour. Because of that, any legal fees that the other side incurred, and there were two other sides that both of those respondents incurred after the point of that offer, she then had to pay. So just her costs were estimated at that point to be around $250,000, and she was an individual. So you can imagine that the costs that she was ordered to pay at that point, it ended up being appealed, but at that point would have probably been, I'm guessing, $500,000 at least, whereas the damages that she was awarded was $18,000. So, and that's like a win. So there's some data that was collated by some very smart people, Professor Margaret Thornton, Kieran Pender, and Madeline Castles, in their paper, Damages and Costs in Sexual Harassment Litigation. And so they found that since 2001, applicants have been ordered to pay costs in 52% of sex discrimination cases, 55% of disability discrimination cases, 47% of race discrimination cases, and 50% of age discrimination cases. And in 10% of cases, of sexual harassment cases, successful applicants have been ordered to pay the costs of respondents. Those are very daunting figures to look at as someone who has been subjected to that conduct. And these are the people that end up pursuing their matters. So since 1984, so the introduction of the Sex Discrimination Act, there have only been 444 sexual harassment cases brought to court. So some very smart people have done some research and figured out that this is the ACTU, have figured out that only 1 in 230,000 victim survivors of workplace sexual harassment end up bringing proceedings in court. Since 1984, only 95 federal sexual harassment cases have resulted in an award of damages. So putting that data together, we can come to a conclusion that since 1984, there have been just under 21,900,000 victim survivors who have not been awarded damages in their cases. And that's very concerningly high.
Ellen, can you draw on some of the experience of the Justice and Equity Centre and your work specifically around running disability discrimination matters, and your thoughts on why the law needed to change?
Yeah, sure. So the Justice and Equity Centre has a long-standing discrimination practice, particularly representing people with disability who have faced discrimination and are seeking systemic change to try and improve the accessibility, particularly goods and services. So over the course of that history, we've run a number of test cases on access to services like public transport, education, digital and emerging technologies. So the clients that we are acting for are usually seeking recognition of discriminatory conduct and wanting respondents to change their conduct. They're less concerned with damages, but of course, many of them have also suffered real and compensable loss. Through that work, we've had some important wins through litigation and trying to, I guess, improve accessibility through the discrimination law. Some examples representing Graham Innes in his claim for failures to provide audible station announcements on Sydney's trains. And we've also had many other cases that haven't gone through to hearing but have settled, often with favourable outcomes, in the sense of respondents agreeing to make some improvements. So we've worked on the Commonwealth Bank's FPOS machines and a range of cases against airlines. But sometimes that means not getting the full recognition of a court finding of discriminatory conduct. And litigation in the disability discrimination space, I think, like sexual harassment, is difficult. Cases don't go to court and damages are low. Recent Australian Human Rights Commission figures, they receive upwards of 1,000 complaints under the Disability Discrimination Act per year. In 2021 and 22, it was close to 2,000. But that same survey of discrimination cases that Seri mentioned from 1994 to 2021 showed that only 313 disability discrimination cases had made it to a federal court, and only 20% of those resulted in an award of damages. And the average damages awards are very low. For general damages, the average is about 13,000, and it really hasn't increased over the time of the Act. So the average in the last kind of 5 years is still $16,000. So that's not a lot of damages that we're talking about. And there's also limitations in the legislation and case law that's developed that has kind of further limited that, so that it's a very complex area. There's complex arguments about comparators, whether conduct was because of a person's disability, and the provisions around reasonable adjustments have been interpreted in a way that makes them often not helpful. So that's also limited the number of cases making it to court, and there's limited scope then for the courts to address some of those concerns with the interpretation of the legislation, just because there's not cases making it through. And of course, the system of complaints to the Commission and conciliation, that's intended to resolve matters between the parties without litigation. That, of course, has its benefits. It can achieve good outcomes, but it really relies on the respondent cooperating with the process and having sufficient incentive to genuinely participate. One thing that can provide that incentive is the prospect of litigation if it's not resolved. And like Seri, in our experience, our clients in particular are not in a position to take on the risk of any significant costs order against them. Paying even a modest bill of costs would bankrupt them or mean they have to sell their home. So what we have had to do to enable clients to do that is a range of things. One is to try and secure indemnities from various sources, public interest litigation funders like Grata Fund, or supporters of the person bringing the claim. But that's difficult. You can't do that in a lot of cases. We've also used protective costs orders, so you can apply to the federal court, and also the federal circuit and family court has a similar regime, to have an order up front about the maximum cost that might be payable in that case, referred to kind of colloquially as a cost cap. That can limit the amount of costs to a more manageable amount, give some protection, but that process, well, those orders are discretionary. You need to make an application at the outset of the litigation and provide substantial supporting evidence to demonstrate a kind of range of factors that can be taken into account in that kind of application, that there's a public interest element to the case, that the applicant couldn't proceed without the order, and a range of other factors. And those kind of provisions haven't necessarily been applied consistently. You can't kind of guarantee that you'll be successful in that. It's also an intensive process at the outset of litigation. It's kind of a whole set of evidence and hearings before you've even started the case. Often those cost caps are reciprocal. So the cap applies to both parties, and that can limit the applicant's ability to recover their costs. And that can also affect their ability to access legal representation, because if solicitors or counsel need to act pro bono or under conditional costs agreements, it might be more difficult to obtain that. representation. So those arrangements aren't suited to all cases.
And so having heard about the difficulties under the past regime, Maria, how did you determine at Grata what reform should look like and how the bill should be drafted?
So I'd had very similar experiences to Seri and Ellen when I worked as a employment and discrimination lawyer at Kingsford Legal Centre for a number of years. And when I started at Grata Fund, our founder Isabel, who has great vision, said to me, we're going to reform the adverse cost system because Grata Fund was set up to remove financial barriers to public interest litigation. So I was tasked with that. And to be honest, I didn't have that much experience in costs before I went to Grata Fund. So we started work in 2020 on mapping how the cost system works across the country. So the court rules across the federal jurisdictions, state and territory jurisdictions, and also looking at the available options to limit costs. So I remember the lovely Michelle Cohen, who's very smart and had a lot of experience in this area. I remember calling her up and saying, how does it actually work in practice with protective costs orders and that sort of thing? Because I didn't have that great an understanding of how you could limit costs, but also I was starting to understand that there wasn't that much literacy within the legal profession or litigators in the options available to do so, or even the availability of indemnities and these sorts of things. So, you know, as lawyers who see clients day to day in CLCs and other legal assistance organisations, the sort of advice that was being given was very much based on the risk, based on cost risks in various jurisdictions, because of course there are different options in employment and discrimination law. And that could really, I think, play into what choice of jurisdiction a client made. So we mapped out the cost system and leading cases. We met with leading public interest litigators and barristers, academics, other experts from the sector, including Redfern, Women's, JEC, and others, to get their views on the current issues with costs and what options for reform there were. And then we had identified as part of that process, you know, various cost options that we thought were best practice internationally. And one of them was called qualified one-way cost shifting. And it was in place in the UK in personal injury matters, in South Africa in constitutional claims, in Australia in whistleblowing legislation and taxation legislation. And we thought this is actually a great model. The name wasn't so great, so our wonderful in-house campaigners came up with equal access costs, which I think just shows you how good campaigners are at creating narratives that lawyers might not be so good at. So we started referring to it as the equal access cost model. We're very happy that that's now what it's known as, because qualified one-way cost shifting is really hard to spell.
Not sexy.
And we decided actually this model actually would be ideal for opening up the courts to public interest litigants. And then it was just about trying to identify a political opportunity where we could achieve what everyone was telling us was impossible and a really radical reform. So, you know, previously in my KLC role, I'd worked with RLC and Women's and others to advocate for cost reform for a cost neutrality model like the Section 570 and the Fair Work Act in the Respect at Work reforms. But then when I looked at this equal access model, I was like, that's actually way better in terms of people being able to access legal representation, which I think is a major barrier when each party has to bear their own costs. And then so we decided to just go for it with Respect at Work, because we thought this is something that has bipartisan support, the recommendations, and it isn't, you know, obviously the Respect at Work report when it was released recommended cost reform, but that was based on a cost neutrality model or the Fair Work model with each party bearing their own cost. And we knew a bill was going to be going before Parliament to implement those recommendations. We knew it was high on the agenda of the attorney at the time. So we thought, well, this is a political moment. Perhaps we can achieve equal access costs in this area of law as a pilot, and if it then works, perhaps just say, hey, it worked here, it didn't lead to, you know, floodgates being open or lots of vexatious litigation, then hopefully roll it across the country more broadly for other public interest litigation. But it was a really, really difficult fight, I think. Like, people who are on our side were telling us there's no way there is no way you'll ever get this through. We had lots of meetings and we were shameless about using all our networks and all our contacts to get meetings with ministers, with people at the commission, with people who kept saying no to us until someone we knew who they liked asked them for a meeting. And we were getting a lot of pushback from, I guess, legal heavyweights about this model because of concern for respondents or small businesses. And then I thought, okay, how are we going to get this moving, because we're not getting the support we need? So we decided we'd do it ourselves. So we drafted an amendment to the Australian Human Rights Commission Act to sort of do the model of the equal access model and how it could work. And then we started shopping that amendment around to various senators, and our campaigns team was great at doing the political mapping and figuring out who we should target. We met with a few people who weren't keen, and then we met with Monique Ryan, who actually said, sure, I'll introduce it as an amendment to the Respect at Work legislation, which was great and was a great vehicle for forcing the conversation and forcing the government and Parliament to engage with the equal access cost model. And then, you know, we were really fortunate in that the Respect at Work legislation passed, but the sector had done so much work around the equal access model that the only recommendation that didn't pass was costs, and the Attorney General's Department held a review into what cost model would be the most appropriate model. And here we are today with it in legislation. So we're very excited about it.
And obviously, you know, some of the organisations here today worked on it, but it was part of a much broader movement of lots of organisations within the legal sector and outside the legal sector. Are there other things you had to do to build support for the model?
Yeah, so we Grata Fund is a litigation funder. We're not a frontline service, and we're still very young, only started in 2017. So we definitely needed to collaborate with other experts who have a lot more credibility in the space than we do in terms of a history of representing clients in these public interest matters, and also in terms of getting access to the human story. How have the cost rules impacted real people that all the frontline services work with, and also to get access to that expertise of others as well. So we briefed everyone we could, you know, various CLCs that I've mentioned, and, you know, Kieran Pender did a lot of advocacy work, a lot of academics did advocacy work, and the Power to Prevent Coalition led by VLA and KLC and others did a lot of work getting support from the unions and the sector more broadly. And we also, you know, in trying to build institutional support, decided to try and get the peak legal professional bodies to support the model. So we briefed the Law Society of New South Wales. They agreed to support the model. They then recommended it to the Law Council, who of course did not support the model in the end. But I think it was still useful for us to be able to say, well, the largest peak professional bodies of lawyers in the country, representing 40,000 lawyers, does support this model, including their employment lawyer representatives. So it was just really about talking to everyone we could possibly reach out to, and recognising that the sector had such broad knowledge and expertise that could be used. And I think that's what got it across the line, the pressure from a really broad sector of organisations.
Great. Ellen, can you talk us through exactly what has changed? So how the legislation has changed?
I can, and the only slides we have for this presentation are just to show the changes. Previously, costs were at the discretion of the court. So the general position that costs follow the event has been the approach taken in discrimination cases generally. There's been several cases that have confirmed that explicitly, and said that absent a clear parliamentary intention in the legislation for a different regime to apply, usual cost principles should be followed, which means that a successful defendant should get their costs. In the federal discrimination jurisdiction, cases can be taken in the Federal Circuit Court, Federal Circuit and Family Court, or the Federal Court. And in both jurisdictions, you generally have a cost follows the event approach. In the Federal Circuit Court, there is a scale of costs, so that can limit costs payable, but it can also be departed from if the court decides. In the Federal Court, there's a significant discretion. You can have all sorts of cost orders depending on the circumstances, but again, in general, costs will follow the event. So that was the position previously. Those are the sections. Section 214 of the Federal Circuit and Family Court Act. Thank you. Section 43 of the Federal Court Act deal with costs. So now we have the Australian Human Rights Commission Act, new provision, section 46 PSA on costs, which, and I have this in front of me, applies to proceedings in a court that relate to an application made by a person, so an applicant in respect of a respondent to a complaint that's been made to the Commission. So this requires the court to order a respondent against whom the applicant is successful to pay the applicant's costs. So the applicant still gets their costs if they're successful. And you can still have indemnity costs. You can, there is an exception if the applicant's unreasonable act or omission causes the respondent to incur costs. Oh no, causes the applicant to incur costs, then they don't have to make the order in respect of those particular costs. So it's directing the court in terms of how it can make its cost orders. And then on the next, the other side of the coin for applicants, the applicant must not be ordered by the court to pay costs incurred by another party to the proceedings. The applicant may be ordered to pay costs if the court is satisfied that the proceedings were vexatious or without reasonable cause, or the court is satisfied that the applicant's unreasonable act or omission caused the other party to incur the costs, or there's these exceptions for where there's not a significant power imbalance between the parties, or there's not a significant financial advantage that the respondent might have compared to the applicant. And we'll come back to those because that's the kind of carve-outs, I guess, that were put in there to deal with concerns about the impact on respondents and small business. So those are the key features there. We've gone through those. But I just wanted to point out some of the things. So obviously it's a much better position for applicants. It enables them to obtain representation on a conditional cost basis because there's a prospect of them recovering their costs if they're successful. But it's also without the enormous risk of having to meet an adverse costs order. But there's still a few things to consider and to be resolved by the courts. It's obviously a new legislation still to be tested as to some of the meaning of some of those parts of it. So in particular, in the exception for unreasonable costs, there's a question about what is unreasonable. In the Senate inquiry, there were, into the bill, there were several submissions that raised concerns about this meaning of unreasonable and what kind of conduct that could cover, and in particular how that could interact with offers of compromise or call to bank offers. So could the rejection of an offer be seen as unreasonable conduct, and would that make costs from that point potentially then subject to the adverse cost order? So in response to those submissions, there wasn't any change to the legislation itself, but the explanatory memorandum was updated to provide some commentary on that, and says that that unreasonable act is intended to be a high threshold reserved for rare cases, a mere refusal of a settlement offer, refusal to participate in a conciliation, the running of novel arguments, or a self-represented litigant's lack of legal expertise or acts done because of a disability are not intended to amount to unreasonable acts or omissions, absent a consideration of other circumstances. It goes on to talk about when the refusal of a settlement offer might be reasonable. So there is a suggestion that an offer refusal might be enough to change the position, but it has to be an unreasonable refusal. Of course, that's in the explanatory memorandum. It's still got to be tested in the courts. But there is also some guidance, I think, from the Fair Work Act, which also refers to an unreasonable act or omission as one of the grounds on which a party might be able to pay costs under Section 570. And the jurisprudence there suggests that it is a high bar. And some of the commentary on that, simply because the party does not conduct its litigation in the most efficient way, does not mean the court should exercise its discretion. And so the kind of usual conduct of proceedings and forensic decisions made at different points of the proceedings about how to run it shouldn't get you across the line for unreasonable, but we're just not quite sure where that line is as yet. And then there's the questions about the power imbalance question and the financial disparity. So the explanatory memorandum again does give some guidance about when you might have a significant power advantage over the applicant. So it's intended to be, the power advantage concept is intended to be broad and include consideration of historically unequal power relations, as well as social and cultural power imbalances and organisational power imbalances. So they give some examples. A senior, older or long-standing employee may have a significant power advantage over a junior, younger employee, and various other factors might apply. But again, we can, I guess, expect to see some arguments about whether there's a power imbalance between the parties. And then in terms of financial disparity, I think that was a kind of late amendment to the bill to take account of some concerns about the impact on small business. And so where the respondent has limited financial resources and isn't then in a kind of significant position of financial resourcing compared to the applicant, then the provisions might not apply. But the explanatory memorandum again does say that this should only apply where the respondent is successful on all grounds. So again, there'll be some decisions to come about what that really, how that will work.
Very interested to hear about the carve-outs. So I'm assuming they weren't in the original drafting?
We had included a carve-out for applicants engaging in unreasonable conduct, essentially, because we thought we'll never get this through otherwise. And that had been operating a similar one in Section 570 of the Fair Work Act, and the jurisprudence was fine. But yes, the power disparity and financial disparity stuff was, or financial situation being taken into consideration, was not something we had drafted. It was added in later, and Grata and JC and others did make submissions to various inquiries about why it wasn't appropriate, but I guess it was what was needed politically to get the bill through, because one of the major concerns was impact on small business.
And is there other jurisprudence in other acts, apart from those that Ellen's spoken to, that can give us some guidance on what the impact of those carve-outs might be?
Not that I'm aware of, but I haven't looked into it.
From my brief investigations into that, I couldn't find anything about the power imbalance and the financial disparity kind of, but I'm sure, you know, people will look to other areas as to find some kind of guidance on that, but haven't found anything obvious as yet.
I wonder if it could possibly be used positively in other areas, and that the financial position of an individual, I'm thinking about possibly a respondent in like a defamation claim or something, if it could be used in considering not to order costs against someone in that sort of a context, if there's like if there is a positive spin on it that we might be able to see in other areas of law. But I feel like when in everything that exists now, costs are decided based off the conduct of the parties in the proceedings or the outcome of the proceedings themselves, not how much as money is in the person's bank account, which is quite an interesting departure.
Yeah, I guess it remains to be seen. And I'm interested to hear from all of you on how this new regime will impact the advice that you're giving, or is already impacting the advice that you're giving to clients in various jurisdictions.
It is already impacting advice that we're giving. It's a lot. My job is a lot easier now, in that, I mean, in that I don't have to be as cautious when I'm telling people that they have a good claim and that I think they should proceed with it, and that the real focus of when we're discussing risks is actually how it's going to just affect them, and then considering the strength of the legal arguments, but not whether it's going to bankrupt them possibly at the end of the day. It also means that hopefully we can explore some novel areas of law. So like Ellen was saying, there aren't many discrimination cases, so that's across all types of discrimination, and that makes it difficult as a lawyer, and then even more difficult as someone who isn't represented, to understand if their case is strong. If it is strong, how much is it worth? What other orders can I expect aside from a financial sum? And this now, hopefully, is going to lead to more litigation in general, more judgments, and testing of areas that haven't been tested yet or haven't been tested in a long time. So, for example, in disability discrimination, for direct discrimination, there has to be a comparator. But in some iteration or some instances of discrimination, there isn't always a comparator, but conduct has still clearly been taken because of a particular protected attribute that someone has. And so that needs to be tested. But without this cost protection now, someone would really be sticking their neck out as an individual to try and test that point. And now they can do that and hopefully get really great representation with a conditional costs order, get all of the evidence that they need to gather, which can be quite expensive, and proceed with the case and put the best case forward as well. So the advice that I'm giving now to clients, where I might have previously advised them to go to the Fair Work Commission and lodge a sexual harassment claim because of the 570 equal cost model, I would now tell them to go into the federal jurisdiction. The only downside or only reason I would tell someone not to go down the federal route would be because of the time constraints. So if someone's on a temporary visa, for example, and it's unlikely that the commission would deal with it urgently, then I might recommend that they still proceed down the Fair Work Commission route. Anti-discrimination New South Wales, there is a cap of $100,000 for compensation in these matters, and there is thankfully an upward trend in on the amount of damages that are being awarded in these types of cases. And so purely from a financial perspective, I would not advise someone to go down that route. But hopefully we are going to, as lawyers, be able to advise with more certainty about the prospects of success someone has, the type of outcome that they're likely to receive, and that they won't that they won't be bankrupt at the end of the day. Yeah, so basically empowering people to pursue their claims.
Aria or Ellen?
I don't give legal advice externally anymore. So I'll sit this one out.
Well, I think in terms of disability discrimination, it's still very difficult to pursue a disability discrimination claim in court. It's still hard to kind of get a case that has the kind of prospects that you want to see in order to advise somebody to go ahead with it. But I think now we can advise with more confidence on that adverse costs risk question. So as long as you run the case reasonably, then you shouldn't have to pay the respondent's costs. You're just not going to be on the hook for that. And that is a huge barrier that's been removed. There are some extra things for us to think about, though, as we're going along the way. So the impact of an offer of compromise, whether that could be rejecting that at some point in time could be considered unreasonable, and then open up the exposure, and also making sure that we are conscious of that potential carve out for unreasonable conduct, and being potentially extra cautious about some of those decisions along the way. There's also still a question about whether clients are prepared to take that small remaining risk on in pursuing their claims. But in terms of choice of jurisdiction, I think like Seri, some of those considerations have changed. So previously the state and territory tribunals generally are lower cost risk. Those jurisdictions are usually no costs. They're also designed to be a cheaper and more accessible forum. So you might still choose that kind of forum for other reasons as well. There might still be reasons why you choose that forum for differences in the discrimination laws between the jurisdictions, and some of those advantages in terms of access or ability to kind of self-represent more easily. But now the cost risk for the federal jurisdiction is substantially reduced. So just as an example, the JEC, when it was PIAC, ran a mental health and insurance project for many years, where we advised people on possible options for challenging insurers who denied cover or put broad exclusions on cover on the basis of the person having a mental health history. Often that was kind of life insurance type products. And in a lot of those cases, we advise people to complain through state or territory mechanisms, because if they were to take that complaint beyond the conciliation stage, the cost risk was much lower in the state-based tribunals. But from a systemic perspective, a federal case, particularly if you got to a decision, would be much more useful in that context, because it will clarify the law applying to insurers that operate nationally. Their insurance is not generally a state-based kind of system. So, so I think, you know, in that, if we were in the current position at that time, we might have had more clients advised to go through the federal system. So it's already impacting our advice in quite a few different ways.
And Maria, can you speak to other impacts that you think these laws will have?
What we're hoping to see is victim survivors actually being able to take their cases to court. That's the whole thought behind reforming the cost system and opening up the court so people can actually enforce their rights. And we're hoping if that does happen, we're going to see more class actions, like the class action being brought against Rio Tinto, and more jurisprudence. We know, as everyone's said, that very few discrimination matters historically have made it to court. The law is very complex. We could all be assisted from some judicial interpretation of how the law actually applies. And we hope we'll get some precedent which will aid in creating that normative change or systemic impact in terms of workplaces and service providers understanding that they are accountable under discrimination law. They really need to be taking the steps necessary to make sure that they are providing services or providing workplaces free from discrimination and harassment. It's very confronting, I think, for most baby lawyers when you start practicing to realise the law exists, but people just flagrantly aren't following it, and there's very little you can do. There's no stick if the regulator doesn't do that much. And litigation is a stick that is very rarely used in these areas. So we're hoping it will create that cultural change.
So that's a really great explanation of like the point of public interest litigation, and I think really counters those floodgate arguments around why jurisprudence is important.